Sorry, we swapped on
I got it wrong. Okay, sorry. Well, I think, but I'm wrong. Kate is going to go first.
Thank you so much, Steph. So we're going to use some slides. So thank you for that introduction, and thank you for having us today. So we were talking about the threats to the rule of law, and at the time there was a petition where people had signed to challenge the rule of six, which was impacting the rights of children and families. And it made us think about, how have we got here? And does this represent a challenge to the rule of law? There have been many ways in which children's rights have been impacted. The school closures, the rights of children and young adults with autism, children with mothers in prison, children with special educational needs. And there is a wide disparity. We talked about all being in the same boat when the schools were closed, and there were very tight lockdown restrictions on our lives. But of course, we were all restricted in the same way, but we weren't in the same boat. And there has been a wide difference in how these restrictions have impacted children's access to education. So what is the legislation that has enabled the restrictions following the global health pandemic caused by the coronavirus? So the primary legislation is the Coronavirus Act, but we also have seen secondary legislation that has been issued under both the Public Health Control of Disease Acts and the Civil Contingency Act. The Coronavirus Act came into force very quickly. It was fast-tracked through Parliament and in fact was debated in a single day. The Act aims to support the government in doing the following: increasing the available health and social care workforce, easing the burden on frontline staff, containing and slowing the virus, and managing the deceased with respect and dignity, as well as supporting people. The implementation came largely through delegated legislation, and this has been done through the affirmative resolution procedure. Usually, and the normal procedure for doing so in the convention is to lay it before Parliament with 21 days in order that it can come under some scrutiny. But in fact, the Hansard Society reported in July that 97 of the 130 pieces of delegated legislation had breached that 21-day convention. So how does the Act provide in relation to education? Well, it provided a power to require or direct the temporary closure of educational institutions and registered childcare providers, power to make specified types of directions in connection with the running of education, and the power to disapply or vary specified existing requirements contained in or arising out of education and or childcare legislation. The Act, in its explanatory notes, talks about the particular challenges and risks to those operating in an educational childcare context, and acknowledges the harmful effect that any break in education may have on a young person's development. And it talked about what is in the best interests of those in education arena will vary according to the level of risk which presents itself in a particular context at a particular time. And so the Act sought to provide a suite of powers so that the government could react flexibly and manage different levels of risk. In addition to the Coronavirus Act, as I said, there were also powers that were issued under the Health Protection Act, and the powers, in fact, to restrict gatherings, what have been nicknamed the Rule of Six, that prevent us from gathering in no more than 6 people, although it now depends on the relevant alert level in your area as to what the restrictions are, came in as delegated legislation. And now I'm going to turn to Sonali, who's going to look at the statement of compatibility that was issued when the Coronavirus Act was brought into force.
Thank you. I don't know, does that mean you can still see me? I hope so. And it doesn't really matter if you can't see me and you see Kate. And also Kate's going to operate the slides at her end, I think, so that's helpful. It may come as a surprise to you, it came as a little bit of a surprise to me that actually the Secretary of State had made a statement of compatibility in respect of the Coronavirus Act, and that in fact a lengthy statement which stated that in his view the provisions of the coronavirus bill as it was are compatible with convention rights. And importantly, and it's really, this will inform how any challenges to the regulations and or the Act itself are brought in the future with reference to what's set out here. And it was specifically addressed to the Joint Committee on Human Rights, of which we will speak a little more when we talk about their more recent report. But the government emphasised that it's important to note that once enacted, the lifespan of this Act and the measures in it are limited, and it will only be enforced for as long as is necessary to deal with coronavirus. And therefore, whenever the analysis in the body of the report covers interference with a qualified right, this is an important consideration which goes to the proportionality of the measure. So all the principles with which we are very familiar, but concentrated in that statement of principle, so-called principle anyway, by the government in that statement. They recognise in paragraph 5 of the statement that there's a potential for the cumulative impact of provisions on certain people's qualified rights, but they consider that there's an overriding public health emergency which presents a very strong justification for any potential interferences caused by the bill's provisions, whether it's by one clause or multiple clauses. So that's the important context which the government has asserted. And you'll see later on, we'll note that the courts have been relatively reluctant to get involved and during the initial lockdown phase and during the early parts of the pandemic. But as things go along, there are opportunities to review how that is working in practice, and also, more importantly, following the initial 6-month extension period, how that's going to be going forward. So if we could look at the next slide, slide 10. So the recent Joint Committee for Human Rights report is really critical of the government's response on coronavirus across the board. And it's really worth reading to see what opportunities for litigation that may provide. In ordinary times, the JCHR report in terms of denial of access to justice, a denial of right to children education, healthcare, and what the impact on children in prison or in detention would ordinarily present huge litigation opportunities. And I use that word advisedly. I'm not obviously trying to sound like an activist lawyer. I'm saying this is our job, to hold the government to account. So it's important to identify, for looking at the JCHR report on the coronavirus, what the focuses are. The JCHR recognised that the central aim of the government was to protect lives, and they recognised that the obligation under Article 2 of the ECHR. But the JCHR say that some groups have been particularly at risk from COVID, that they identify that the impact has been disproportionate in death terms on certain communities, and that's obviously includes children. But they specifically identify that in the context of the lockdown regulations that are, and the broad use of the powers, they've had, not only has their impact been huge, but there's been a huge amount of confusion over the status, interpretation of the guidance and the relationship between guidance and law. And that then has an impact on policing. It has an impact on whether people can challenge convictions. And it absolutely, what they emphasize is it in their summary is that given the speed and the frequency with which the national and local lockdown laws change, it's actually very difficult for people to keep on top of what's legally required of them, what's reasonably expected of them, what their rights are, and how they can enforce their rights. And that's a critical part probably everyone's experience here as a human, as well as their experience as a lawyer in this particular context. So they specifically identify that the closure of schools engages the rights of children, including their right to education. And that obviously, as Kate mentioned, it will have different impacts on different children, but that the government must ensure that the inequalities aren't made any worse during this period. And they already identify in this report that school closures have particularly impacted on those with special educational needs and disabilities, and that the government must address those barriers before they identify what they're going to do in terms of those children returning to school. So they also emphasise that the government must be transparent in terms of its timings of decisions to go into and out of lockdown, to justify their decisions as necessary and proportionate, and they emphasise based on relevant scientific evidence with the precautionary approach to minimising the risk to life. Again, all the familiar principles that we as lawyers use in our everyday representations to government bodies, and our representations to local authorities and to other public authorities. And it's emphasised there that nothing has changed as a matter of law and principle. The real question will obviously come in terms of how that plays out in justification. And the JCHR conclude in their summary by saying Parliament is the right place for the government to announce its decisions. This is going back to Kate's point about the relative scrutiny of legislation and how far that is being extended. And this is particularly so, they emphasise, where emergency powers are being used. And whilst the use of emergency powers, including fast-track legislation and affirmative statutory instruments, may have been justified in exceptional circumstances, which we were in March, they say the use of emergency procedures must be limited to what is absolutely necessary, especially when human rights are at stake. So that lays the framework, we say, for looking at those principles in the context of the children's rights of access to education, the decisions in relation to care, in relation to detention, and other restrictions on access to services. Now, we know that the courts have been reluctant to intervene. I just wanted to go to the next, before I come to the courts, can we go to slide 11? Just specifically, before we come back to what remedies are available, looking at the children and right to education, what the JCHR identified was that instead of issuing a direction under the Coronavirus Act to close educational establishments and properly justifying the need to close schools, the government actually did this through press announcements, and really what they did was they encouraged schools not to allow pupils to attend except in certain groups, for example, key worker children and parents, and encourage parents not to send their children to school. And so the JCHR said that we consider the measures are likely to affect human rights should have a proper legal basis, be properly justified, and not be announced through a press notice. Again, that's unsurprising in ordinary times. It's actually not surprising in the time we're living in now, and we should not accept it as being consistent with the rule of law unless it is absolutely necessary in an emergency context. So I think that we've got some food for thought and legal challenge there. And critically, the legal status of such measures should be communicated so that parents and children know on what basis they're being denied access to school. Otherwise, to do so raises a real question under the rule of law and human rights concerns. And that, I think, is absolutely critical. I don't know whether anybody got a letter or an email telling them why they or their child was not allowed to attend school. And in fact, I didn't see any communications like that. And it's really important that we put the onus back onto the public authority to act lawfully and consistently and within their powers. Can we just go to the next slide, 12? This is again the emphasis that the JCHR put on the generic problems with the lockdown regulations, which then specifically apply in all the contexts that we are talking about in relation to children, the rule of six and so on, which is that there isn't a clarity between rules and guidance. There isn't certainty as to what's criminal and what isn't. the rules aren't, the regulations aren't accessible. People don't know where to find them. They're not put to them. You have to look for them, and there aren't sufficient changes, warnings about changes in the law. And indeed, and those regulations should have flexibility in respect to some individual sets of circumstances. They reference specifically protests, but they also reference other gatherings, including family gatherings. I just think, in view of the time, I wonder if we could just skip to slide 16. Might just be a bit of a. I think we're not going to get through our 16, our so many slides. Thank you. So, just before the court, we asked the government, the JCHR has asked the government to respond, and there hasn't been any specific response yet, apart from some ministerial statements, which is effectively asserting that they wanted that the rule of six achieved a balance, and that was the best that the government could come up with. But ordinarily, when we are scrutinising legislation, legislation is scrutinised in Parliament, both primary and secondary. And ordinarily we'd have a consultation period before we had legislation, and subsequently legislation would be tested through the courts, and then that's how the balance of our power effectively is maintained. There's been relatively little consideration by the courts in relation to scrutiny of the coronavirus legislation. Just put up some of the most recent cases on the screen there. And I won't have the last one is concerned with, well, in fact, the court found that Christian Concern didn't have standing to bring as victim status under the Human Rights Act. That was, I think there's a missing line there. But the key case there is for the purposes which we're talking today, is the Shaw case, which was unsuccessful. It was a rolled up judicial review, I think that's right, on the challenge to the modifications and obligations of local authorities to make provision for children with special educational needs and disabilities. I'm just checking my time. If we could just go to the next slide, which is slide 18, I think. So how would we challenge restrictions? We obviously in the ordinary way would seek a declaration of incompatibility on primary legislation, seek a quashing order with regard to secondary legislation, which is actually, as we can see, what most of these issues are concerned with, or even more so policy-based. If there's prosecutions, you might want to think about a Boddington defence as to whether or not, in fact, the appropriate criminal offence was in fact enacted through appropriate legislation with the relevant vires. I just, on the next slide, because I've got 1 minute, or probably no minutes, I just wanted to remind ourselves what the ordinary proportionality test is, even in the sort of national security context. And that test is still the applicable test from when we are holding the government to account with regard to those principles. Whether the objective is sufficiently justified, important to justify a limitation on a fundamental right, is it rationally connected to the objective? Could a less intrusive measure have been used? That's the key here. And then the balance. So that's what we want to do going forward, is to look at the relevant regulations that have been applied to children and families, and look at what the justification is. What's the evidence base for it? Would hold the government to account. So the final, that's what we say is the way in which the litigation can be successful, or at least try to encourage an appropriate scrutiny. It may be that the litigation isn't ultimately successful because the court will apply a sort of margin of appreciation in this context. But the reality is that is the process that should be gone through, and the government should be required to produce the evidence base to justify the conclusion that they have reached. Thank you. I think I've gone over time, sorry.